Hi, and welcome to the 10th episode of my vlog, Personal Injury Lawyer Tips. My name is Angel Leroy Rudder. I'm a personal injury lawyer specializing in catastrophic impairment law. I'm also a published author of the LexisNexis Inc. book called Catastrophic Impairment Law in Canada, a director at Head Injury Rehabilitation Ontario, and the founder and owner of my law firm, Rudder Law Group. In this vlog, I'll be discussing the difference between the traditional approach to determining causation in a negligence case versus the more modern, robust, and pragmatic approach that has been adopted by the Supreme Court of Canada, which offers more flexibility in the court's ability to weigh the evidence of both parties. Historically, our jurisprudence in Ontario and Canada has always required a strict proof of causation, where you, the plaintiff, claiming negligence on the part of the other party, typically the defendant, had to show that, on a balance of probabilities, 50% plus 1, the defendant's conduct or behavior caused the injury that you sustained, in order to impose liability on the defendant to pay your compensatory damages. However, in other countries such as the United States of America, and more notably, the United Kingdom, another principle was explored, which saw the onus of proof of a lack of causation shift to the defendant if you, as the plaintiff, could demonstrate that the defendant materially increased the risk of the injury you sustained. This debate over which approach was preferable was finally laid to rest in 1990 by the Supreme Court of Canada within the context of a medical malpractice case. In the Supreme Court of Canada case entitled Snell and Farrell, the appellant was an ophthalmologist who performed surgery on the respondent, Miss Margaret Snell, to remove a cataract from her right eye. The ophthalmologist saw no signs of retrobulbar hemorrhage, injected a local anesthetic into the retrobulbar muscles behind Miss Snell's eyeball, waited 30 minutes, and then proceeded with the surgery. When Miss Snell's chamber cleared approximately 9 months later, the ophthalmologist was able to see for the first time that her optic nerve had atrophied, resulting in a loss of sight in her right eye. And guess what? Yes, one possible cause of optic nerve atrophy is pressure due to retrobulbar hemorrhage. So was the cause of Miss Snell losing her sight due to the ophthalmologist failing to see the retrobulbar hemorrhage and proceeding with the operation, or something else? Neither of the parties' expert witnesses was able to state with certainty what caused the atrophy in this case or when it occurred. The trial judge found the appellant ophthalmologist liable in negligence. The Court of Appeal dismissed the appellant's appeal. The Supreme Court of Canada dismissed the appeal of the Court of Appeal's decision after finding that the evidence supported the jury's drawing of an inference of causation between the ophthalmologist's negligence and Ms. Snell's injury. In doing so, the Supreme Court of Canada addressed the question of whether the traditional approach to causation is no longer satisfactory, in that plaintiffs in malpractice cases are being deprived of compensation because they cannot prove causation, where it in fact exists. Concerning the underlying reason for why the traditional approach to causation has been deemed to be less satisfactory in plaintiffs' malpractice cases, the Honorable Justice Opinka of the Supreme Court of Canada stated the following, quote, "The traditional approach to causation has come under attack in a number of cases in which there is concern that due to the complexities of proof, the probable victim of torturous conduct will be deprived of relief. This concern is strongest in circumstances in which, on the basis of some percentage of statistical probability, the plaintiff is the likely victim of the combined torturous conduct of a number of defendants, but cannot prove causation against a specific defendant or defendants on the basis of particularized evidence in accordance with traditional principles. The challenge to the traditional approach has manifested itself in cases dealing with non-traumatic injuries, such as man-made diseases resulting from the widespread diffusion of chemical products, including product liability cases, in which a product which can cause injury is widely manufactured and marketed by a large number of corporations," end quote. Therefore, the traditional approach is strict proof of causation, where on a balance of probabilities, the plaintiff has to show that the defendant caused his or her injury. has come under attack because due to the complexity of causation in some cases, like medical malpractice cases, where the defendant is in a better position to know the cause of the injury, there is a fear that some plaintiffs won't be able to prove causation unless the defendant has the burden of disproving causation. However, in order to address this fear, the Supreme Court of Canada made it clear that no court should resort to utilizing the legal principle or doctrine of res ipsa loquitur, the thing speaks for itself, which has created so many problems in our Canadian jurisprudence until it was finally laid to rest by the Supreme Court of Canada in 1998. If you want to learn more about the legal doctrine normally known as res ipsa loquitur, then please read my blog entitled The Modern Application of Res Ipsa Loquitur. The Honorable Justice Sapinka quoted from J.H. Wigmore's book entitled Evidence in Trials at Common Law, when he noted that the legal or ultimate burden of proof is determined by the substantive law upon broad reasons of experience and fairness, and then went on to note the two broad principles in a civil case as follows. 1, that the onus is on the party who asserts a proposition, usually the plaintiff. And 2, that where the subject matter of the allegation lies particularly within the knowledge of one party, that party may be required to prove it. On the basis of the first basic principle, as was alluded to before, it is very difficult for a plaintiff to prove causation in complex medical malpractice cases. On the basis of the second principle, the physician who performs surgery is more knowledgeable about and in a better position to know the cause of the injury, and as such, an argument that the burden of proof should shift to the defendant begins to sound more plausible. However, in response to this plausible argument, Supreme Court of Canada was also quick to point out that the, quote, dissatisfaction of the traditional approach to causation stems to a large extent from its too rigid application by the courts in many cases, end quote. Despite the fact that it has long been recognized in our jurisprudence that the allocation of the burden of proof is not immutable or unable to be changed over time. And as such, both the burden and the standard of proof are flexible concepts. The Honorable Justice Sapinka defined causation as, quote, an expression of the relationship that must be found to exist between the torturous act of the wrongdoer and the injury to the victim in order to justify compensation of the latter out of the pocket of the former, end quote. He reminds us that causation doesn't have to be determined by scientific precision. Lastly, he also reminded us of the importance of weighing the evidence in accordance with the proof by quoting Lord Mansfield in Blatch and Archer as follows, quote, it is certainly a maxim that all evidence is to be weighed according to the proof, which is what in the power of one side to have produced and in the power of the other to have contradicted, end quote. So what does this all mean? In a case such as a medical malpractice case, where the facts surrounding the cause of the injury sustained by the plaintiff, such as a patient, lie particularly within the realm of knowledge of the defendant, such as the surgeon who performed the surgery, it would be extremely difficult for the plaintiff to adduce the evidence necessary to justify the drawing of an inference in the absence of the evidence from the defendant to the contrary. However, this can occur without a shifting of the burden of proof from the plaintiff to the defendant. Rather, the process that occurs is that the direct or circumstantial evidence adduced by the plaintiff patient may result in an inference being drawn that's adverse to the defendant's surgeon, where the determining factor of whether or not the adverse inference is drawn is the weighing of the evidence in accordance with the proof, which is a normal step in the fact-finding process of a trial. So, the burden of proof doesn't shift to the defendant's surgeon to disprove negligence, but rather the defendant's surgeon runs the risk of an adverse inference against him or her if the defendant chooses not to adduce evidence to the contrary. Again, this is not a shift of the burden of proof to the defendant's surgeon, but rather an imposition of a provisional or tactical burden. The Honorable Justice Sapinka eloquently stated how the traditional burden of proof from the party who asserts the proposition of negligence, such as the plaintiff patient in a medical malpractice case, is flexible enough to coincide with the provisional or tactical burden on the party, such as a defendant, surgeon, who is in a better position to know the cause of the injury to the patient as follows, quote, "The legal or ultimate burden remains with the plaintiff, but in the absence of evidence to the contrary, adduced by the defendant, an inference of causation may be drawn, although positive or scientific proof of causation has not been adduced," end quote. This is what it would mean to adopt a robust and pragmatic approach to the facts, in order to enable an inference of negligence to be drawn that the defendant's negligence materially contributed to the plaintiff's injury, even though medical or scientific expertise cannot arrive at a definitive conclusion. I hope you found this information valuable. If you want more information, then please read my blog of the same name called "What is the Difference Between the Traditional Approach to Causation and the Robust and Pragmatic Approach to Causation?" In my blog, I take a deep dive into the difference between the traditional approach to determining causation in a negligence case versus the more modern, robust, and pragmatic approach. I also provide links to other blogs such as "How do you determine liability when at least one of two negligent defendants caused the accident, but you can't prove which one?" which will provide additional information you'll find helpful. My website is your one-stop source for answers to all of your legal questions concerning tort law, personal injury law, and catastrophic impairment law. If you want to book a free consultation with me, then please visit my webpage at RudderLawGroup.ca and click on the free consultation button at the top of the page. Let us be your rudder that steers your legal ship in the right direction. Please subscribe to my YouTube channel and click the like button if you found the content valuable. There you'll also find other vlogs of valuable content on tort law, personal injury law, and catastrophic impairment law. Thank you, and I'll see you soon in episode 11 of Personal Injury Lawyer Tips, where I'll bring you more useful legal information.